the thing. For the rest of the talk, what I'm really going to focus on is what's a county to do. You're going to see the slide with the red bar in a different place a couple of times. So really, there's three options in light of the new law. The first is let projects go to the Public Service Commission. The second one is adopt a CREO, a compatible renewable energy ordinance. And the third is come up with a workable but incompatible ordinance, WIO you can say for short. And I'm first going to talk about what each of those mean, and then talk a little bit about the pros and cons of each. Okay, so the first option, again, what you could do as a county is just say, let it go to the state. Let the state process kick in. So again, this is an option to go to the state, but when it's available, when that option is available to developers, the pathways to that are listed here. So first, the local government could say, we just want things to go to the state. We don't know how, actually. There's not guidance about like how to do that, if you pass a resolution, if you put it in your zoning ordinance, but that's an option, and the law is explicit about that. You can just, a local government can say, any of these big projects, we want them to go to the Public Service Commission. The other time that the Public Service Commission option is available to developers is when not all local governments have a CREO. Or, alternately, if any of the local governments in the place of a proposed project have a moratoria, then the developer is allowed to go to the state. Again, I'm going to explain the CREO in a minute, but I just want you to see what the state level process is. And then the third time that going to the state is an option for a developer is when the local government, who says they have a CREO, delays acting on an active proposal, when they get a proposal from a wind or solar developer, or when they deny the project. And then the developer can go to the state. This is, if they go to the state, this is the state level process. So it kicks off in this green bar here, which I don't know that it's showing up as green, and now I'm realizing I'm going to stick at the microphone so that you can hear me and I don't shade it. Okay, the first thing that happens is that they have to go to the chief elected official in each local government and say, hey, we got a project, will you meet with us? 30 days later, we're going to talk about what happens in those 30 days. But then, the next thing that they have to do is notify the clerk in each of the local governments that they're going to have a public meeting. That's shown here in yellow. And actually, all of these timelines are backed up from that public meeting. Then they advertise for the public meeting, and then they host the public meeting. It's not the local government that hosts it. It's the developer that hosts the public meeting. You'll note it's a public meeting. After that public meeting, then they are allowed to file their application with the Public Service Commission. The Public Service Commission has 60 days to say whether it's a complete application. And if it is, once they have a complete application, the Public Service Commission has a year to approve or deny the project. If it goes through the Public Service Commission process, there are some standards that are set in the law, but a lot of things that are commonly in zoning that are not in the law. There are some like setback and sound standards, and I'll get to that in a future slide, that are in the law. The Public Service Commission also has evaluation criteria to evaluate project proposals that have pretty broad authority to apply conditions. Like, they can condition their approval on a lot of things. It's not clear to me when they can actually deny a project, but they can require a lot of conditions. If a project goes through the state level process, the developer has to give local governments a grant to effectively be able to intervene in the Public Service Commission process, because it's not like a local zoning meeting. Like, you have to hire special lawyers. It's a formal intervention. And so there's funding set aside to be able to do that the developer has to pay. Also, projects that go through the state level process, developers have to pay a one-time host community agreement to the local governments, and it's $2,000 per megawatt. The other thing that happens at the state level process is if a project goes through there, there's requirements that they have apprenticeship and prevailing wages for construction workers, so it effectively requires union labor to go through that process. I just say, all of these things, many of these things are not necessarily typically required at the local level. And so there is some sense that this process could be more expensive. Could is an important part. There's also some research from other states that finds that it's a nationwide survey of wind and solar developers. Looking at other states, they find wind and solar developers say going through state level processes is more expensive than going through local processes, in part because of some of these requirements. Okay, that's what it would look like to the developer if they go through the state level process. And you could just say, we don't want to deal with this, go there. Another option, and the way that you stop a developer from going through the state level process, is to have a CREO, a compatible renewable energy ordinance. In this, the developer starts out by saying, hey, we want to develop a project. And they're going to have this meeting with the chief elected official in your jurisdiction. You effectively, the reason that they have this meeting is that chief elected official has 30 days to say, no, wait, we have a CREO. And then the process stops. The developer can't go forward. As long as each, let's see, is that on the next slide? If all local units have adopted a CREO, the developer must first have the project reviewed at the local level. You'll see I added color, which is not in the law, to this. Okay, so first, all. What does that mean? That actually is the huge, nobody knows question. The plain reading means, because the law says that units of government are counties, townships, villages, and cities, and that any of them where a project is in their geographic territory they are considered affected. The plain reading of the law means that a county is always an affected local unit of government, right? Because you're always in a county in the state of Michigan. It could be that, you're then always in either a township or a city, and maybe you're in a village too, right? What we know, though, is that from the Zoning Enabling Act, they can't all have zoning ordinances. So there's some assumption that this supplants zoning, but not all of them can have a zoning ordinance, because that's what the Zoning Enabling Act tells us. The intent, I'm going to say, I don't think that was intentional. I think that the intent behind this was probably that what was meant with the zoning authority. And effectively, what the Public Service Commission's straw proposal says is that the only people that need to have a CREO are the people with zoning jurisdiction. But importantly, it does not say that counties, if you do not have the zoning jurisdiction, that you are not an affected local unit of government. That's not in the staff's straw proposal. They're just saying you can't, if you don't have the zoning jurisdiction, you can't have a CREO. That hopefully makes you breathe a little bit of a sigh of relief, at least temporarily, although this is something that industry is very much fighting back on. They effectively want only affected local units of government to only be the ones with zoning authority, because it affects how much money they pay in that $2,000 per megawatt. But at least right now, where the MPSC staff is saying is, it makes it clear that it's only the zoning authority that needs to have a CREO, but counties, regardless of whether or not you're the zoning authority, you are still an affected unit of government, and you can still intervene in the project by right, and you can still have access to the $2,000 per megawatt funds. Okay. Also, this is really important if there's a project that spans 2 counties. Okay, but that's not the only thing that is highlighted in red. So that's all. It's also, what the law also says is the developer must first have the project reviewed at the state level. Because if the local unit that says that they have a CREO fails to approve or deny the project in 120 days, If they amend their zoning ordinance or they deny a proposal that adheres to the standards laid out in the law, then the developer can go to the state, to the Public Service Commission. If you have a CREO, again, now we're on the path of like the county, and again, now, according to the current staff recommendation, you are only gonna have a CREO if you're at one of the 23 counties with some sort of zoning authority, right? If you have a CREO, the developer is going to file their application, and then your local process kicks in. But the big thing is that there is a time clock in here of 120 days. The law allows for extending that another 120 days, but that has to be on mutual agreement with the developer. All right, what is a CREO? That's what everybody also wants to know, because if you're a zoning authority, you need to know, like, do we currently comply? It's an ordinance, the requirements of which are no more restrictive than the provisions in section 2268. I have listed all of the provisions on this one slide for all three technologies. It is very thin. Solar and storage have similar setbacks. Actually, wind and all of the technologies have the same noise limit. There's some requirements on lighting, fencing and height for solar. For wind, it's effectively, you have no height limit. Your only height limit is what the FAA says is no hazard. So the question that those of us who deal with zoning a lot and have written sample ordinances say, like, can nothing else really be in a CREO? We don't know. It's to be determined. So one of the things that is sort of in staff's straw proposal is effectively maybe a CREO can include regulations that mimic the MPSC standards or conditions. It's not clear whether or not you in a CREO, you can say that there needs to be compatibility with land uses and land use plans. It's unclear whether things that are customarily in zoning, like screening and landscaping, are allowed to be in a CREO. This is the thing though, this is why it really matters, is that if you say you have a CREO, and then you either deny it because for anything other than complying with these things, if the developer meets the standards that are shown right here, if you deny the project for any other reason, the developer can go again to the state and you lose your intervener funds. You can still intervene if you want to have a say, but the developer is no longer paying for your intervention. And you might no longer the law says you can no longer claim CREO status. The staff proposal says until you change your ordinance to be more compatible. Okay, that's CREO. There's a lot of unknowns still, but we can talk about it more. The third option is a workable ordinance, a workable incompatible ordinance. Anybody who has zoning right now, well, actually, before I move on to that, we have the zoning database. We collected the zoning ordinances for everybody as of last year. So we read through them for solar, and I can tell you that there's fewer than 100 CREO solar ordinances, and that's assuming that you're allowed to effectively say it's not allowed in the multifamily district. So statewide, out of 1,300 zoning ordinances, there's fewer than 100 that are CREO just from the things that are on here. In wind, there are very few, like 5 in the entire state. So most people don't have a CREO right now. The question is, like, can you have a workable ordinance? What is a workable ordinance? It is not in the law. This is a Sarah makeup term. What it means is it is something that the developer can live with. And effectively, it's the thing that they say, I would rather deal with the local government than spend all of the money and time and go through the state government. So in order for them to make that assessment, this is what I told the state, first of all, everybody needs to know what the developer and local governments need to know what the state bar is, right? So that they can do that comparison. But there is no technical term for workability. Effectively, what I would also say is it's possible that you're cool with all of the setbacks and noise standards. You just want to have screening for solar. or something else. It could very much mirror the standards in the MPSC process, or it could deviate from them. But effectively, what makes it workable is that you're not killing the project, right? The developer still feels like they can do a project in your community. How to tell? I mean, I'm not a developer, so like developers right now are the best way. I don't love that though, and actually I didn't update this slide. Okay, so one thing that you can do is look to what works, what's worked before. You're not going to be able to do that with storage because we don't have any storage projects that are of this scale in the state right now. But you can look to what other communities that have hosted a wind or a solar farm, what their standards are. Some of my former students that now work for Eagle have done this. They've pulled together the recent solar ordinances and the conditions of approval that any place with a wind or solar farm has put on a project. So you've got some bar of what has proven workable in the past. But the thing that I didn't put on this slide is that we also just got some money. We being Eagle, Michigan Association of Planning, U of M, MSU, from the federal government to effectively, among other things, create a calculator that helps local governments understand, so you don't have to trust the developer. Like figure out how expensive it is to go through the state level process and what the room for your negotiation is. It's not done yet. I mean, we didn't technically, the ink has not dried on this grant, but it's coming because I want communities to be able to understand kind of what how valuable their place is for wind or solar and kind of what they can ask for reasonably.